And we have any number of people that have ingestion type of deaths, suicidal deaths, where you ingest some substance. And here, when we ask for the breakdown of what types of products or pills that people are taking to kill themselves, we got this breakdown. And remember, Dr. B went through it and she marked how many were actually overdoses from benzos and opioids. Very dangerous drugs. Lynn was thinking about her death. She wrote her own obituary. She'd been thinking about her death since at least 2016, because that's when this particular document appears to have been written and notarized by one of the bankers at BMO, who came in here and indicated that's her seal, that's her signature. She's the one who notarized this document. Misspelled Jessy's last name. She can't spell names. But Lynn wrote that. Jessy wrote that. She's not going to misspell her own name. Make no mistake about it, Dr. B is called this cause of death tetrahydrozoline poisoning, that and that alone. That's what she says the cause of death is. She's never had a tetrahydrozoline death. She has no experience with that at all. Zero. This is the inventory that was taken of all the pills at Lynn's home and what was prescribed and what remained. 0, 0, 0, 0, 0, 0, 1, 0. Lynn took a boatload of drugs. When the first test was requested from NMS Labs and it came back, it didn't even check for baclofen. How is it possible that you really paid attention, doctor, to what was at the home? There's bottles of baclofen here, and you don't ask for baclofen tests to be done. It's a deadly drug. Henry Spiller said to you, that's the bad boy. In this case, that was the bad boy. So she's got it. Yeah, she ran a lot of tests because, oops, I forgot to check for baclofen. Need to run it again. What were the drugs in her? Baclofen, cyclobenzapine, hydrocodone, alprazolam, nifedipine. Not fatal levels. The state says these therapeutic levels. Therapeutic levels? No.
She was well known to like drugs and alcohol. That never changed. Lynn grew up that way, and she stayed that way. Maybe the pills changed, or the alcohol changed, or the drug of choice, but that's what she did. So it's just, it's so frustrating sometimes. Just thinking of like how she was.
I'll tell you this: she didn't overdose on any kind of prescription medication.
Okay.
Everything was at therapeutic level.
Therapeutic level. No. Dr. B testified that Visine, which is the product we know with tetrahydrozoline in it, testified about it. We know it's been on the market since 1959. We didn't hear about any reported deaths. She says it's outlawed in France. That's not true. It's not outlawed in France. It's not approved. No one sought approval. It's not outlawed. It's being careful with our words, not trying to mislead you, ladies and gentlemen of the jury in this case. There was no evidence presented that any company was denied approval of tetrahydrozoline or Visine in France. It's misleading, as was Dr. Kasinko's abstract. Misleading. She put statistics on there, statistical trickery. Well, maybe that's a little harsh on her. Maybe that might hurt a little bit to hear that. But that's how Henry described it. He is so experienced in this area of toxicology. He's peer-reviewed toxicology articles for other people that want to print them and have them published. He's the peer reviewer, one of them, not of his own, of course, and it wouldn't pass muster. And I understand that she's a younger scientist. I understand that she wants to find a novel subject to write about. I understand wanting to be recognized. But this is only an abstract. It's not even a written article, much less submitted for peer review, much less next step, go to be published in any kind of literature. Henry, on the other hand, has written and published at the Nobel level. I mean, we're talking over 200. A 44-page curriculum vitae, CV. These were the positive findings that came through, and look at what she has in her system. It's just incredible to see the number of drugs and the quantities of the drugs. And maybe one alone, fine. But the combination, deadly. Dr. Thomas said it was a polydrug overdose. Where does tetrahydrozoline rate in the dangerousness of the drugs, according to Henry Spiller, world-renowned expert in toxicology? At the bottom of the list. At the bottom of the list. Remember also Dr. Kasinko bringing in an article that in her rebuttal, she came back up for like a last rebuttal. She brings in some article that is from somebody she met at a conference. It's been cited twice. In other words, no one's citing that article. It's cited twice. It's not well received in the toxicology community because it's not being cited. Now, Henry Spiller is able to, with his decades of experience at working at National Poison Control Centers, where he's doing real-time work with people in hospitals who are in for overdoses. And he is dealing with the doctors and the nurses and the hospitalists and the emergency room people, and he's trying to calculate what's going on and what's in their system. Remember, a girl says, I took 20 Tylenol, and he says, no way, didn't take 20. I know based upon the levels I'm seeing, it's 30 or 40, whatever the number was. He knows that, he does that. It's what he does to save people's lives. And he follows the patients, doesn't he? From the minute he gets the call from a hospital that somebody's on an overdose through their discharge or their death. He knows how to calculate how many pills. Nobody else knows how to do that that was in this trial. And he calculated that Lynn has 33 to 42 tablets. And it's higher than it was originally because other drugs were found. Because remember, there were pills in her belly, right, that were never tested. But he did the calculation, 33 to 42 pills. That is a boatload of pills, consistent with this boatload of pills, bottles, mostly empty, not all, found at the scene. And nobody's shoving 33 to 42 pills down somebody's throat. No way. Remember, Lynn was a savvy pill taker. She'd been taking pills and all sorts of pills for a long time. No one's going to trick her on her pills. Lynn knows what she's doing. She's been taking them for years. And there's no indication in the record that anything was forced, because I specifically asked if there's any sign of injury to a mouth, to a throat, a trachea, anything to suggest that there's any kind of forced ingestion, and there isn't. There is not. She took them herself because she wanted to. And as to those other cases that were cited by Dr. Kasinko, for example, Henry Spiller actually calculated the amount of tetrahydrozoline that was in that child at peak. 115 ng per milliliter. Now there's a scarcity of cases. You think that we should be able to come in here and show you case after case after case of tetrahydrozoline and what levels should be, but there aren't. If they were out there, we would have them here for you to see. But there is that case where he's able to do the calculation. 115, Lynn was 160. 115 had a little bit of problems, a little bit of respiratory depression, used a little mask of oxygen on the child, rapid improvement. That's what 115 ng per ml does to a little child. And he made a point to let you all know that children are not little adults. The effects on a child of any kind of drug are going to be much higher, stronger than that on an adult. Yeah, the five pills. 5 pills found in Lynn that the medical examiner never tested. And in fact, didn't know what they were, never bothered to figure out what they were until we met with her and pointed out the number 30 on one of them, and couldn't that be nifedipine? And between that date and when she came into court, she agreed, she looked it up to see if we were right, which we were. She said, you were right. None of this was taken into consideration by her at all. Never tested them. What kind of medical examiner, when you're talking about a poisoning, so fixated on the THC? Why did she fixate on it? She'd never seen it before. I agree. Probably, if she says that, it's probably true. It's Sherry Kasinko from NMS Labs who was all excited, wasn't she, about, at that time, about this high level of THC, because she's wanting to do this article. She's got an abstract. She's getting her lab automatically tests for THC, and now she's got this case with a high level. She wants to be recognized. She wants to cite it, so she gives a suggestion to Dr. B that this is fatal. This is what killed her. Because what other evidence is there of it? There's not. It's not true. There's a lot of drugs in her system. Dr. Thomas told you that. Mr. Spiller told you that. You can see the charts for yourself. It is just an incredible number of pills. And Lynn wasn't healthy. Dr. Thomas was careful to tell all of you about the other problems with Lynn, like her fatty liver disease, which shows the alcoholism, the stenosis that she would have thought if there wasn't anything with drugs, that there would have been a heart issue that might have killed her. Her obesity, she's 251 pounds at death. How did she gain? You know, from earlier records, we see 50, 100 pounds. This is incredible weight gain. She's type 2 diabetic, the pulmonary disease, the interstitial myocarditis, the heart hypertension. The woman had a lot of health problems. And Jim Berg was in court to talk about her finances too. He said that she was broke. She knew she was broke, tying into financial things. This wasn't news to her. But before I leave on the medical part of it, remember, Henry Spiller said that he did write an article about tetrahydrozoline and its effect in sexual assaults. And he said he wrote it and did the research on it because he wanted the FBI to adopt this as one of the standard tests that they use when rape kits are done. And of course, when the FBI makes recommendations, you don't have a city or a state is free to reject or accept them. But his goal was to get the FBI to recognize that THC, to make the testing for THC part of the recommended national protocol, I think is what he said, when they're testing blood or urine. And that's probably, isn't it, why NMS labs ultimately put the testing for tetrahydrozoline in their regular testing regimen, because they get all blood or urine to test in all sorts of cases. People use the lab not just because somebody died, but for any reason, including you could send urine for a rape test. And so they accepted that recommendation, it seems, and put that as part of their regular testing. So when it comes to first-degree intentional homicide, the state has not proven it. They have the burden to prove it beyond a reasonable doubt. They didn't do that. They failed. Such a serious charge. Defendants aren't required to prove their innocence. The law presumes every person charged with a commission of an offense to be innocent. The burden of establishing every fact is on the state. Ladies and gentlemen, if you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so. You must do so. Return a verdict of not guilty. And as to the homicide, that's exactly what we have here, an absolutely reasonable hypothesis of the defendant's innocence, and you must return a verdict of not guilty if you agree with that. There are other words in jury instructions, such as you should, but here this one is must. It's must. Of course, the last part of the instruction, and what no doubt the state will indicate to you when they get back up here, I don't get a second turn. They'll say, you know, it's your duty to give the defendant the benefit of every reasonable doubt, but you're not to search for doubt, you're to search for the truth. But by their own admission, all we have here is circumstantial evidence. There is really, that's all it is. It's a circumstantial evidence case. I don't know, it's not easy to search when you're missing so much information, like testing of pills and saving of evidence at a scene. And I did, and I hope you can see my chart, because I think it's important to look at how, what does that even mean, reasonable doubt or proof beyond a reasonable doubt? It's such a legal term. It's hard to understand it. But you can look at this chart and kind of get an idea. If there's no trace of evidence, of course, well, that would be not guilty. But even if there's any evidence at all, a scintilla of evidence, that would require a not guilty. If you have a reasonable suspicion, which should be based on specific or particular facts or reasons, it's not based on a hunch or a guess, so it's more than a hunch or a guess. Call that a reasonable suspicion, not guilty. What about if you got probable cause? You hear that all the time, even if you're watching TV. We got probable cause, we're going to get a warrant, or probable cause for this or that. Reasonable and trustworthy information that a particular person has committed a particular crime. What if we have that? If you think that there's that here, that's a not guilty. Well, let's go even higher on the chart and think about what if we've got the greater weight or amount of evidence? In other words, there's a greater weight of the state's evidence compared to the defense evidence. If you felt that, which I don't, based upon Dr. Thomas and Henry Spiller, but if you felt it, it still requires a not guilty because that's only a preponderance of the evidence. That is inadequate to convict. Even if you have a firm belief that the allegations are true, in other words, clear and convincing evidence, you must vote not guilty. That requires not guilty. And if there's any reasonable doubt, it's not guilty. Only if the state presented evidence that went on that ladder, those stairs, all the way up here, would you be able to vote guilty? And I submit that as to the first degree, intentional homicide, the intentional taking of Lynn Hernan's life, that they have not proven their case. I do want to talk to you about the financial things. So, the state suggests that Jessy was taking all this money from Lynn. Actually, Lynn and Jessy were close, and Lynn gave Jessy money all the time because she wanted to. And Lynn spent a lot of money before Jessy was even on the scene. We took the total account balances, and you can look at it if you want to dig through the financial records. We've added things up. And you can see that in 2014, she started with $346,000. And by January 15 of 2015, she's down to $305,000. And by January of 2016, we have her down to $272,000. And the first check that was written to Jessy, ladies and gentlemen, was in July of 2016. And this continues on for the rest of the accounting. But remember, the first checks to Jessy are in July of 2016, and FBI, who we brought in here, again, the state did not bring in the FBI. They didn't want you to hear from the FBI. The checks written to Jessy, she rated them as a common source. Support for common source. Now, I know that this chart is not the easiest chart to understand. I had to have it hammered in my head again and again. So, of course, they never say they're certain. Apparently, the FBI doesn't do that. But we've got inconclusive in the middle. We're not sure. As we move to the right, it's more likely that the person wrote it, and as it moved to the left, it's more likely the person didn't write it. That's really how this goes. So all the checks that were written to Jessy, the name, Jessy Kurczewski, not always spelled correctly, and the numerals were support for common source for Lynn. That Lynn likely wrote the Jessy's name and the amounts. As to the signature, the Lynn Hernan signature, because of the lack of clarity in documents that she had at her disposal, she was inconclusive. That isn't a support for a different source. It's inconclusive. And I think there was a suggestion during this trial, as I recall, somebody suggesting, well, if Lynn had duplicate checks, wouldn't Jessy be able to duplicate her signature from the duplicate check? Well, first of all, that's a if. There's nothing in this record that Lynn had duplicate checks. So that would be a guess. We're not here for guessing. If Lynn had duplicate checks, bring in somebody from the bank, from the deluxe check ordering company. The state should do that, right? And say that Lynn had duplicate checks. There's nothing in this record that she had. But second point, we know, don't we, from our duplicate checks that the signature is blacked out. They've done that for years. on duplicate checks just for the purpose that if somebody steals your checkbook or you misplace it, you lose it, that people aren't going to see your signature. So that's just ridiculous. Now we have known writing of Lynn. This was known writing of Lynn. Lynn liked to spend money. She liked to give money away. She liked to spend beyond her means. She liked to give away beyond her means. That's what she did. And giving money to Jessy made her happy. Jessy was like her daughter. Jessy was the person who was there all the time, and Jessy probably gave her a hard luck story. I need money for this and money for that, but Lynn was happy to give it to her. The crime requires that it be without her consent. There's no evidence here that Lynn didn't consent. Lynn, in fact, gave the money willingly to Jessy. But she liked to spend money, and she liked to give it away. As I told you, check item numbers 47 through 56 and 58 through 83. Those were support for the writing being of Lynn's. She wrote the body of those checks. And the two in between that, I should point out, because you might be wondering, well, where's 50 or 67? I think this 57. They were confirmed as Lynn's signature. I'll look at how her spending dramatically increased. So here we've got Lynn going to the hospital. She got $19,000. She has a discussion on September 21st with palliative care and spend. Once she knows that she has to either go in a nursing home, which she doesn't want to do, she's made a decision. And it's spent and spending. And that's when the ATM withdrawals began. And Lynn liked to have cash. Of course, she sent Jessy to do things for her. Lynn's discharged from the hospital, and she's down quite a bit of money, and is all after her discussion with hospital people about the palliative care, having to go into a nursing home, or having full-time care at her home. Withdrawal. Okay, now think about the two loans you heard about in this trial. You heard that Lynn applied for a loan first with her primary bank, which is BMO Harris. And there, if you looked at the documents carefully, she did exaggerate her income. It was exaggerated about 50%. She did note on those applications exactly what she had in the bank, and the application was done face to face. In other words, she was there at the bank doing the application, and she put down how much money she had in her bank account, and it was under $20,000. The suggestion has been made that Lynn was being taken advantage of and had no idea of her finances. False. She knew. She put it on her loan application. Now that was denied. So by increasing her income by 50%, she doesn't get the loan. So they together decide to make the application for Goldman Sachs. Goldman Sachs, they put up its income of $100,000. It's obviously poor underwriting, never looked into anything, but they accepted the documents and they gave the loan. They approved it. And on the day of the disbursement, the key thing is Jessy added Lynn to her Wells Fargo account. She was added. And as to switching the names and adding her to the account, that was done in person too. We brought in the man that did that form with Lynn and Jessy at the bank, and he told you, you'll be there in person in front of him with identification to prove who they are. Not only that, But he's so careful to make sure that people are not being taken advantage of, that both the customer and the, both people, both customers before him are not being taken advantage of, that are in a good mental state, that they know what they're doing, and that in fact, we heard that all the banks do that. That's part of protocol. They just make sure that they don't see anything, that somebody isn't nudging somebody or signing for them or whispering and telling them what to do. So they did go for a loan, and there were obviously falsities told about Lynn's income of $100,000, but she wanted the money because by the time that February of 2018 rolled around, she didn't have much money in the bank. She just applied for the loan at BMO, and she had listed her assets at under $20,000. So Lynn was well aware in February 2018 that she only had $20,000. As to the theft from Lynn during her life, the state has failed to prove it. The record before us shows that Lynn gave Jessy the money willingly. She had no one else to give her money to. You might question it if somebody has heirs that are alive, like children, grandchildren, that you might want to leave your money to, but Lynn did not. She wanted Jessy to have it. She knows she's going out. She's giving it to Jessy. It is a lot of money. It's a tremendous amount of money. But just because it's a lot of money doesn't mean that Lynn didn't approve of it. And in fact, the evidence suggests she did. Jessy was the person that was there. No one else really knew knew Lynn like Jessy. She knew her. They're the ones that spent time every day, twice a day, together. And Lynn made a decision. She made a decision that she was going to exit. And she did that on October 3rd, once Jessy had left the home. We know it was then because of how long the body was deceased. The body was not dead in the morning. The rigor would have spread. That's just false. She put on her father's dog tags. That's a sentimental thing to do. That's when you're thinking about going to another place to be with your loved ones. I'm going to join her father, the person that she loved so much. She put on his dog tags.
And I don't mean that in a mean way. I mean it truthfully. She did a lot for me. So the fact of her being dead would do what for me?
Well, the debt's kind of coming up to overtake the assets. She has more credit debt than she has money.
Yeah, that's what I'm saying.
So the money's running out.
Yeah. So, but I don't get what you mean by that. Yeah, they were. I don't understand what you're saying.
The fact is she paid you $200,000 over the last 2 years.
Mm-hmm.
You're the prime. You are handling the money. You are on the signer on the accounts. You are running the show.
Yeah.
You are handling the credit card stuff.
Mm-hmm.
You know what's going on financially with her.
Mm-hmm.
The money is going to be gone here shortly.
So I would kill her because of that?
People do weird things.
Why would I kill her for money?
I mean, it's just...
It's my family.
I tend to think that you didn't... When you say kill her... I don't think you killed her. I think she was sick, and she didn't want to... She was done.
Yeah.
And she wanted to finish her life. And she needed help.
And even if you think, as the detective did, that that's what Jessy did, that is not a first-degree intentional homicide, which is what is charged here. Look at the elements of the crime. That is not it. Even the detective thought it. As to count 2, the state has not proven beyond a reasonable doubt that Lynn did not consent to giving Jessy that money. And in fact, she did consent. And remember, if you can reconcile the evidence on count 2, the theft while Lynn was alive, with any reasonable hypothesis consistent with Jessy's innocence, you must do so. You must do so and return a verdict of not guilty. As to count 3, which is the theft from the estate, really the only comment I would make to you, ladies and gentlemen, as you heard during the case, the estate's not even closed. The estate is still open. When you go to the jury room and you deliberate and you look at all this evidence, and if you want to see something, send a note. We'll send it if we can. I ask you to return verdicts of not guilty. The state has not proven their case. The only true and correct verdicts are not guilty. And thank you.